you just made me feel good. You told me that even though we're generations apart, I've been practicing probably 3 times as long as you have, that you rely on paper while I'm relying on the digital stuff. So that made me feel good. There's a lot of attorneys in our office, young attorneys in our office that are relying on paper. They've got to see it and stuff. And I guess that tells us that it's always going to be a choice. Not everybody's going to go to one or the other now.
For me, whether it's a case or pleadings, I like to have a physical copy because I read it and I highlight it. In paper, I like to be able to feel it and just, I don't know, it's easier for me. Digitally, I feel like you have to go back and you can't just, I don't know, it's just easier.
Do you feel that's true for going to court, that you prefer paper rather than digital?
I think when I have it prepped for my cases, since I read the pleadings ahead of time on paper, I take the paper to court, so I already have it set in line. But digital is so much more convenient because sometimes you have RFOs that are like this big, and you have to trot along little cart. So I think it just depends. Sometimes the digital does come in handy for court.
What year did you start?
2018.
Okay. So what you should know, I wanted to check that. I thought it was about that time period. Let's go back 10 years ago or maybe 15 years ago. We'd go into court with boxes, because you just never knew when the opposing counsel was going to bring up a fact, and you had to fact check it with a piece of paper. And most of the time, those boxes would just sit there. I got into the habit of getting into the digital stuff as soon as it became available. I rarely bring paper to court with me, and even in trials now, because you rely on your trial books, you don't really need to go back and look at it. And, if they're really good, you get a printer with you, and just in case, if you have it all downloaded on your printer. But I tell you that there's a lot of attorneys in this office that still prefer the paper.
I mean, I think Anthony's with you, another attorney. He loves to have his Dropbox link, and he just pulls everything up from there. But I'm old-fashioned. I like the paper.
There's one risk. There's a couple of risks. One of them is the internet working? If you're relying on downloading stuff while you're sitting there in court, that could be a problem. Been there, done that. The other problem is what happens if the court doesn't have something to allow you to plug your computer in and you're there all day. I've been in a panic mode a couple of times where my battery's getting to 0 and I forgot to bring a plug, or there's no outlet available, and it's like, oh my God,
you're scrambling.
So there is a downside to it, but it seems that the courts are getting a little bit better, in providing things for us. The central court still has a long way to go. But I noticed that they've upgraded the chairs in there, and they've got some screens on the walls. So hopefully they're going to get it set up so that we're a modern courtroom, and we have the ability of plugging in our devices. Yeah. So, I actually did a full hearing with nothing but my iPad once, not too long ago, and I didn't feel like it was out of place at all. I was there. I don't know what the judge was thinking. He might have thought that I came in unprepared, But so, cool. So here we are, 2021. Okay, the year.
Happy New Year.
Yeah, New Year. Well, more importantly, this is the day after the inauguration. So how are you feeling?
I feel like a sense of relief. There was so much buildup to this. I wasn't sure if we're going to have like military, taking over the Capitol. I wasn't sure if there's going to be more riots. It was kind of scary.
You know what? That's what Maria said, my wife. She said that she lost sleep. She got a headache, angsting about what could happen during the inauguration. Me being in law enforcement and prior military, I knew there was a snowball's chance in Haiti that there was anything that was going to happen. They had 25,000, at least 25,000 National Guards there. They had the FBI, the Homeland Security. If the Civil War protected, the people of the Civil War protected the Capitol, they were going to do so against these crazy people that wanted to, do a second chance at this. But yeah, there was a lot of people that had a lot of anxiety. Other than that, though, how do you feel? You feel like it's a breath of fresh air. We're in a different era. That's how I feel.
It's totally different than when Trump took office. I think they were saying Biden has like the most diverse cabinet in the history of America, which I think is very different than what we were seeing with Trump. So I'm optimistic. I will see what comes of this. I think, regardless of their politics, it seems that at least the people and Americans themselves are much more united and there's not so much divisiveness. So I'm hoping that we can bridge that gap because for a while it was pretty ugly.
Yeah. I loved his speech. I think that the inauguration speech was the best one that I've ever listened to. I loved his speech about, unifying and get rid of the uncivil war. People can disagree politically, but it doesn't have to lead to war. He seems to be the right man at the right time, to deal with what's going on right now. And his job is really big. I was thinking historically that there's only two presidents that I could think of that had bigger challenges ahead of them as they were entering the office. One was Abe Lincoln. He's coming in and the nation is literally falling apart.
Right.
There's a civil war that started, as he's walking into the office. And then there's FDR. He dealt with the Great Depression. There could be some debate as to whether Biden's tasks are less than FDR's going into that. But FDR also dealt with World War II. Of course, that was, he was a 4-term president. But here we've got Joe Biden, who is a very amicable guy. And you got to figure that he's somebody that a lot of people like. He was in the Senate. He's moderate. The conservatives are backing him right now. They're giving him his blessings. So he seems to be the man for the job, but man, what a job he's got right now.
Well, that's what I was going to say. I think that the best part about it is that there is some bipartisanship. I think that was the hardest part with Trump, that he was so polarized. Even the good that he was doing was just swept under the rug because he was so hated and by so many for different reasons.
He picked so many enemies.
That's the problem.
Yeah.
I was talking to my family. I'm like, it's not necessarily that he did nothing good. There was good things he did,
right.
But because of his facade and the words that he used and the kind of fans that he had that were a little bit too fanatical, you kind of forget all of that and you just see this like horrible, Nazi. And they're saying like the end of Nazi America and comparing him to Hitler, obviously, which is quite the comparison. So I think that at least with Biden, he seems to be more in line with having bipartisanship, which I think is going to hopefully lead to real change.
Hopefully, yeah. I heard a quote I heard Dave Chappelle say on TV that, the one thing about Trump is he brought out a lot of things that were under the rug, and, for many of us, I had no idea that there was that many people that, held the beliefs that some of those writers have, or most of them have and stuff, and so the country has a long way to go. But, we're with a new president. The diversity of the cabinet was incredible. I was talking to some people on a board meeting yesterday, and the ladies uniformly said they cried when Kamala was inaugurated, and then, of course, when J-Lo gave her song, which I didn't see yet, but stuff. It's like, for me, I just saw a part of the speech of the president, and I was almost brought to tears. It takes a lot for me, and stuff. So, what did you get to see J-Lo or?
I got to see some of the performances and some of the speeches, and obviously, Sotomayor is the one that swore in Kamala Harris, which is the first, Latina Supreme Court justice swearing in the first woman vice president. That's history in the making. And I think regardless of your political ideologies as a woman, you just kind of, feel so much, what's the correct word? Like pride, just, growing up as a little girl, I can tell my daughter who's 5, I'm like, look, babe, if you want to be vice president, you want to be president, you actually can. You're that much closer. Before it kind of was a little bit of a story tale, a fairy tale, but now we actually have someone in power that can be a role model to so many.
That is so cool. As a white male growing up, in America, I think that, I've, like many of my peers, you don't deny people the rights. And we always thought that there would be a female president, an African-American president, and so it's like, yeah, well, that's going to happen. But when it does happen, you see how much it means to people. When Obama was president, Maria and I went to Antigua on a vacation. They actually named a mountain after him. There was so much pride and goodwill with that. And I think that this is going to bring that back for a lot of people. And Trump administration caused a lot of hate, and a lot of feelings that it was us against them type of thing. Yeah. So, putting politics aside, I don't like to talk politics, and especially, on public. Even in mixed company, I normally don't. I never post anything on my social media sites about politics or anything, but I think it's appropriate now, the day after the inauguration, to say we're in a different era, and let's just hope that things get back to not only normal, but they get better. So
we're
cool.
putting our trust in them.
Yeah, absolutely.
Optimistically, but we'll see what happens.
Yeah. Just stop the fighting that they have and start working together, for crying out loud. So we're going to talk about fighting today. Okay. We're talking about the case of San Diego County versus PB. Okay, PB being the father, I think, in this case. So why don't you lay out the facts for us?
So basically, mom and dad were married. So they got divorced. They had one son. originally, per the judgment, 50-50, it seemed like things were going to be okay. And then they make note of this one incident. They don't really describe what the incident was, but it was this horrible incident that after then pretty much
In a restaurant.
that dad and the son became estranged. And they kind of stopped communicating, stopped having visitation, et cetera, et cetera. So bad to the point that I think there was some kind of counselor appointed or minors counsel. I'm not quite sure who it was, but in doing some investigation, they kind of found that mom was brainwashing the child or kind of, relaying her negative thoughts about dad to the child that this one incident seemed to reinforce. And then everything went haywire. And then, these people were in court all the time to try to modify custody, and they just could not seem to get it together. I know at one point they tried to do conjoint sessions, and they stuck with the 50-50 custody arrangement. And then that never went through. And then just dad basically not disappeared, but just kind of didn't see the kid at all.
He became estranged from the child, right?
Yeah.
Yeah. So the restaurant incident occurs somewhere around
2011.
2011. Okay. And now they're litigating custody all the way up to the time that the kid's 18 years old practically, right? So there's a good record in this decision about the various court appearances and the attempts to go to therapy and all that other stuff. We're not going to go through all of that, obviously. It would take a long time to do that. But in essence, what happens is that it starts off with was it a 50-50 custody?
It was 50-50 custody initially per the judgment, and then this incident happens, and then kind of custody. I don't actually think on paper custody ever changed from 50-50, but in actuality, he wasn't practicing. Dad wasn't seeing the kid.
There was a mention of 29% visitation, so something happened along the way where it was reduced to 29% or something like that. But to fast forward on the case, tell us what happened. Well, before we do that, there was a allegation of alienation, right? So what was father saying about that?
So basically, father was saying that the reason why he was not, and by the way, just to go back, you're right. So originally it was 50-50, and then after that incident goes to monitored visitation, which is where we get the 29%. And then at that point, they had some kind of schedule where if dad behaved during that period, it would go back to 50-50, which never unfortunately happens because of mom's alienation or dad's claiming that mom is alienating the kid. So this is actually not a custody case. It's a child support case.
And why are these percentages being discussed here and in the decision?
The reason is because, as they may know or we know, child support is based on the disomaster, which in part is each party's income, but in part is also how much time each parent has with the kid. The premise obviously being the timeshare correlates to how much money is respective to each parent based on, the timeshare. So at some point, for whatever reason, I think based on dad's claims that mom was, alienating the kid, mom goes in to try to upward modify child support. And dad rebuts that saying, well, no. If she would let me see the child, then there would be no, difference in timeshare. We'd have 50-50, which is what the original order was based on. And the trial court seems to buy it at first. They say, you're right. These are special circumstances that warrant, putting this false 29% timeshare, even though the record was clear that dad was not exercising any time.
So let me slow it down a little bit. First of all, we're talking about California. California has a guideline formula. In other states, they calculate support differently. But in California, there's numerous factors that go into the formula. And it's so complicated, we have to use a computer. Nobody could scratch it out by hand. One of the big factors is how much time both parents spend with the children. And if you're the quote-unquote non-custodial parent with very little timeshare, it could, and it normally does, impact the amount of support you pay, right?
Right. Typically, less time you see the child, the more you pay.
Okay. The other thing is, in this court, there was two courts. One was the child support court, and the other one was the family court.
Right.
Custody was being dealt with in family court. Child support was dealt with in child support. So when you're talking about the initial comments of the judge, I think that was the child support judge that was talking about that, right?
Right.
And
so
what did that judge say?
He basically was saying that mom shouldn't benefit from her own wrongdoing. So if mom is alienating the kid from dad, she shouldn't be coming to child support kind of with unclean hands asking for more money because it's of her own doing that dad can't see the kid. And I think the child support case actually got the 29% from the family court and then inputted that and then basically said, okay, mom, you're saying he's not seeing the kid, but I'm not going to put 0 because you're the one who's doing wrong. there's, certain case law that dad cited, I think it's Family Code 4057, saying that these special circumstances about mom alienating kid should apply, and he shouldn't be penalized for not seeing the child when
Yeah.
it's mom that's
So
facilitating that.
within California Family Code, there's a provision that says that the court can depart from the guideline formula when it is unjust and inappropriate to do so,
Right.
right, to impose that. Very rarely is it used. In this case, the child support court, the judge there, decided that, you know what, this isn't looking good. You seem to be alienating this child, then it would be unjust and inappropriate for you to receive full child support because you're the cause of him having zero visitation with this child.
And honestly, I thought that was the judge's way, and I think you and I have seen this a lot, where judges try to find creative ways to reach the end they want, and try to use the law to support them as best as they can.
Yeah, right.
In this case, obviously, mom was not going to take it and, decided to appeal it, which we'll discuss a little bit further. But I think that's really what it came down to. The court didn't want to give mom the benefit of her causing this alienation.
Let me tell you a story. There was two judges that I used to appear in front of probably, and I can't believe how much time has gone by, 10 or 15 years ago. One of them was in Burbank and the other one was downtown, and then she was out in Pomona. I didn't really enjoy being in front of either one of them for different reasons. But I was, they were good people, So they were eventually removed, or they transferred, I should say, from the family law bench, and they went into civil. And I'm sitting at the San Fernando Valley Bar Association inauguration day, where they're bringing in new officers. And I'm sitting at the table with these two judges. And we had a conversation about their days in family law. And they both said two things. Number one is going into family law, they thought, this is going to be a piece of cake because we're just talking about families, and stuff. And they said, wait a minute, this is like a whole body of law, and it's very complex. And it was like, oh my God. Second thing that they said was what was really hard for them was knowing what they wanted to do and trying to justify it with the law, right? And they found that very, very difficult. And I think that you're saying here, this judge saw some inequities because there was, evidence of gatekeeping. In fact, in a footnote, talk about the footnote of this decision.
So you and I both talked about this. In a footnote, they basically, as an example of mom, overstepping boundaries, they talk about mom bringing a security guard with the child to a therapy session, which eventually canceled the therapy sessions because obviously the therapist was uncomfortable with having a security guard there for the minor child. And I think that was probably like mom's little spiteful tantrum show of, power with, because who really brings security guard with your minor child to therapy session?
Yeah, that is an outrageous thing. I've never seen that. Now, I've had a lot of cases, one that in particular where father was alienated by his own doing for about 4 years, and then suddenly at trial he wanted 50-50 custody. So, I didn't have a too difficult a case there. But that was one of those cases where the kid would sit in the therapist office, and when the door was open, he'd run out. I mean, he didn't want anything to do with that father. There are some sad cases like that. But in this particular case, there was a therapist that came to court to testify. I believe that she thought that mom had, in fact, brainwashed the child. That wasn't the terminology she used, but she thought that the child was relying on the restaurant incident, which is why you brought this up in the first place.
Right.
To say, and that was how he thought of his father, that one incident. And, there was some evidence that, he wasn't really thinking for himself. In fact, he quoted his mother once about what happened in the restaurant, I think, right?
Well, the child had no separate memories of what he was claiming. When the therapist asked him, he's like, oh, because my mom told me. But the actual child didn't have any recollections of his own about experiences with his father aside from what mom had told him. So I think it was a pretty clear connection between his feelings towards dad being really motivated by mom's feelings or mom's version of the events, if you will.
So we're not saying that mom was doing things right here, right?
Right.
I mean, I don't think the Court of Appeal was saying that either. In fact, it was not shy in spelling out some of the allegations here. And never once did the appellate court say, well, we disagree with any belief that mom was gatekeeping. I mean, it was almost like a given. Okay, she's gatekeeping.
Right. Okay,
and she caused or was part of the problem here. So go on. What happens next?
So basically, the trial court takes these liberties to try to reach an end within the frame of the law, and mom decides to take it up to the Court of Appeal. And the Court of Appeal basically strikes down the trial court and says, no, 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 like, nice try. We know what you're trying to do here. But remember, child support is for the benefit of the child. So at that point, I think there's a quote where they say, mother is nothing but a conduit for the child. She's simply the recipient of benefits that are to benefit the child. Hence, it would not be in the child's best interest that it be a reduced number of support simply because mom's acting out.
So if he's not exercising it, he can't claim more timeshare and the court can't give it to him,
Right.
even if mom's causing it. So it raises two really interesting discussion points that we could have here. The first is the strong policy for child support in America, and especially California, that we see that that's the number one priority of family courts, it seems. And there's no excuse for not paying child support. And even when circumstances seem unjust, the law is pretty hard. They refer to a code in here.
Right.
Is it 3556?
Yeah,
3556. Yeah.
Which basically spells it out really clear that even if a parent is gatekeeping and prohibiting the other parent from exercising custody, it is not grounds to reduce child support.
It's interesting that when people take these things up on appeal, that they first look at the code.
But you know what? I think the dad was emboldened by the trial court, the fact that the trial court found those special circumstances.
Yeah.
Because I actually found it pretty convincing too, until the appellate court cites those specific cases to what those special circumstances really are, which is essentially like when a third party is taking care of the kid as opposed to a parent. If you work and you have your mom take care of your child, or you leave them with a babysitter or a day camp or something, you still get credit because it's technically during your time, you're just using a child care provider. But here the court was kind of trying to make it seem as if mom withholding the child was on level with those. And
yeah, the only time that I've seen the hardship invoked successfully was when I was a child support attorney. And under 4057, the belief was the unjust and inappropriate under the circumstances really dealt with when somebody can't pay. You're trying to impose like the minimum amount, and they just can't do so. There was a case that I had where the gentleman came into the courtroom with let me tell the story. So this was a paternity case, and this woman had met this man in a bar, and they had a one-night stand, and she didn't even know his name. All that she knew is that he went to high school in some place in L.A. County, and she decided to have the baby and not have a father. She was earning enough money. She just didn't want a father. 5 years goes by, and she loses her job, and she's like, I could really use some money. And so who's that father? So she goes to the high school that she remembered him saying he attended, and she went through all the yearbooks.
It's a creative way to figure out.
So she finds this guy, and this guy is like, what? That's not my kid. So, we went through the ordeal whether it was his kid or not. And during the pendency of the litigation, and he was successful. He had a trucking company, and he earned good money. She would have gotten really good child support. So during the pendency of the litigation, he got involved in a boating accident, which reduced him to a quadriplegic status. So on the day of and I'm a brand new attorney, and I'm dumb and don't know how to, anything, right? I'm in this child support case, right?
And you got that curveball. I mean, that was so unexpected.
Yeah. And of course, I'm there to fight for, kids and all this other stuff. So this guy comes in with his attorney. His attorney literally wheels him into the courtroom. And as he's arguing, he takes a piece of the wheelchair and he's banging on the table saying, this would be unjust in circumstances. All he makes is, the disability from his insurance and all this other stuff. And of course, the court granted him, the relief there, the hardship. But that's a classic type of scenario, where somebody is going to get, a hardship. I've never, unjust and inappropriate under the circumstances. I've never seen it where, like in the type of cases that we have, where normally you have, people that aren't even near those circumstances. So the Court of Appeal here talked about 3556, and it said it means what it says, right? That it doesn't matter if she's gatekeeping. You had other remedies. The court talked about the other remedies that the father could have tried at least, rather than, trying to get a greater percentage of time. Talked about contempt, modifying custody,
right.
And things of that nature, right? Which I think is kind of interesting, though, because, the Court of Appeal might not know this, but trial courts don't like contempt in custody cases, right?
Yeah, because it's quasi-criminal.
Yeah, and they tend to just not want to be bothered with it and stuff. And it's sometimes you'll have the contempt by the elements, but if you go forward with it, even if you prevail, you could be considered the person that's got to pay the fees because the other side's the prevailing party or whatever and stuff. It's a dicey situation when people go into court for contempt. So I thought that the Court of Appeal was a little naive in that regard.
Well, even with the modification of custody, the record spoke for itself. This guy kept trying to go back and forth to try to get custody with this kid, and at every angle she seemed to somehow circumvent it, whether it was a security guard in therapy or just not letting the child go. Oh, I don't know if you saw that. I think that's why the therapy ended, because the child actually threatened to commit suicide before a therapy session that later was kind of related to mom's coaching of the child.
Yeah, and the trial court said, we've come to an end here, right? And he's not going to see the child. So there was no hope up until the court had jurisdiction that he would ever have real visitation with the kid, right?
Well, I think the last time they were in court, the kid was 17. So at that point, the court kind of said, you know what, we've done what we can. It's run its course. Unfortunately, it's out of our hands. And at this point, it'll just be mutually agreeable between dad and the child.
Yeah. Oh, boy. So the Court of Appeals spoke. It said that, no, you were wrong. Did it remand it for proper calculation? It probably did, right?
Right.
Yeah.
So it said specific instructions as to what periods of time, because she was contesting like a 5-year period. And during that 5 years, he had different levels of visitation with the child. So for each section, they set certain percentages and parameters for what would apply, and then remanded to the trial court so they could actually do the calculations, run the disto master based on those percentages.
Okay. So there was a second part of the decision that I completely forgot about until today when I was brushing up on this. And it dealt with the Alter-Williamson analysis about the gift that keeps on giving, as I call it. So mom wins on the first allegation,
right,
or first complaint, that, hey, you shouldn't have that timeshare. It's zero. She raises another issue. What was that?
Basically, that the fact that dad's parents were paying for his legal bills, that should have been calculated as income available for support.
Okay.
Which, I actually found this a little bit interesting because generally speaking, we always say that if a party's receiving reoccurring gifts from a parent, they may be considered income. But here, I think because it was so very specific to just his legal bills and not necessarily, living expenses or just loans or just money being given to him, the court declined to find that those payment of legal fees should be considered income to dad.
Yeah, there's two seminal cases. Alter is one end of the spectrum, the other one's Williamson. So Alter was one that the Court of Appeal, actually it cites both of them. First, let's talk about Alter. Alter was a case where apparently the father was being paid by his parents even before there was any child support orders, paying for everything, and that continued out during the litigation. And I believe it was the mother that was paying for his child support, his attorney's fees, and she took the stand and testified that she had done so, and said that she intended on continuing to do so. So that was the seminal case of Alter. The case that I say is the gift that keeps on giving. The court said that's proper to impute that income to this particular father because he's getting it and he's going to keep getting it.
Well, I think that's the difference. That mom, father's mom came on the stand and said, I'm going to continue paying it, so he's still going to be receiving it going forward.
Yeah. Now, Williamson was another case where it was an heir of the Chandler family. Do you know who the Chandler family was?
No, I don't.
So that was the family that owned L.A. Times. Okay, very wealthy family. Mr. Chandler lived here in Pasadena. He actually lived over at the, now it's called the Langham Hotel. At the time, I'm not sure which hotel it was called. But he rented out, or he actually purchased a property that was there, and that came from Dad. Okay, and him and his wife decided that it wasn't good enough, so they moved to Santa Barbara. And he got another mansion. That money came from Dad, and Dad was paying and paying and paying. Eventually, the divorce happened, and Dad kind of stopped paying. And the father says, I've been reduced to living in the basement of somebody else's property. So anyways, there was this evidence that this is a very wealthy family, that Dad, all he has to do is ask for it. And, his father is going to give him money, and that was pretty much in the evidence, that he just has to ask for it. But during that trial, the grandfather, Dad's dad came into court and said, I'm done with this. I'm not paying for this child support. I'm not doing that, anymore. And based upon his testimony, the Court of Appeals said, Alter doesn't apply. It's not a continuous gift that we could rely on and stuff. So
Right.
It was like a bright line. And now it's really hard to make the case for alter, unless you got maybe a deposition of a parent that says, yeah, I'm going to keep paying and stuff. Or, maybe they say they're not going to pay, but after the hearing, they continue to do so. Maybe you come back. So in this case, what happened with regard to these bills? From what I understand, it was payment of attorney's fees.
Right. So his parents were just paying for the attorney's fees to help him out with this situation because obviously, if it's your son and you realize how tragic the situation where they're not allowing him to see his kid, then you're happy to help out. But that was kind of the extent to which they were willing to assist him financially. And so mom kind of couldn't count on that being income available for support because it was solely for this purpose of the attorney's fees.
And it stopped, from what I understand.
Right. It was just for this purpose, for the purpose of this litigation, and then it was over.
Okay. So mom won on one, she lost on another. Overall, how do you think she did?
I mean, based on the arrears and the interest that she probably would have gotten from dad, I think she might have made out. I mean, hopefully it was used for the benefit of the child, right? That's what we can assume, that she was maybe misguided in other aspects of being a mother, but ultimately was doing it for her son's college, let's say. We can hope for that at least.
Yeah. I think the one thing that really resonates from this decision, that's not necessarily a child support issue, but it's the issue of people not getting along and co-parenting, and how a relationship can be destroyed, by a mom influencing a child or a father behaving inappropriately and giving up, and whatever went on. But it's really a tragic story that we see a lot. And I think in a future podcast you're going to have with me, we're going to talk about co-parenting.
Yeah, I think that's something that a lot of parents, I don't think it's always malicious. I think some parents think they're doing the right thing by protecting the child from, whether it's mom or dad, whoever it is. Either mom's unstable or dad's violent or whatever, and they think they're doing the right thing, but they forget how that affects the child 5, 10, 15 years down the line. I mean, thinking about that 5-year-old that you have now, like my 5-year-old daughter, that was a priority for me. I want to make sure that when she's 30, 35, whenever she decides to get married, that her dad can walk her down the aisle and that we can be there and, still be civil with one another and participate with one another, even though we're not necessarily a couple anymore. And I think sometimes parents forget that down the line. They just see this hatred in the moment and don't necessarily act in the overall best interest of the kids.
Yeah, there was an article in the LA Times, not LA Times, Time Magazine, I believe it was. This was probably about maybe 3 or 4 years ago. And it reported on a study that they had conducted, some people had conducted, that showed where they tracked the children of divorces in comparison to those that were not, that were in well-adjusted families. And they showed that the children of the divorced families markedly did not succeed as much as the other half, I think that if you love your kid as much as parents normally do, and you put them first, you've got to consider that. You got to consider, their development and stuff, and their need for a relationship with both parents, But unfortunately, a lot of our cases, a lot of the cases that are out there aren't like that, And so you got a lot of broken up families and kids that are growing up with, developmental issues.
Right, and I think I actually saw that study, and it was based on that I was like, I am not going to let my daughter be that way. Whether he and I are not together or not, we're still a family of sorts, and we're still going to raise her as a family.
God bless you. Cause
it's difficult.
Yeah.
It's not as easy as I'm making it sound. We definitely both have come a long way, and I give credit to my co-parent for that as well. But I think when you really do put the child first, you don't have any other goal but to put the ego aside, put the hurt aside, put whatever happened in the past aside in your romantic relationship, and just focus being on the best parents possible.
Yeah, and hopefully, the quality of your experience as being a parent is enhanced big time, because you're not dealing with, the ickiness that goes along with it. You're both doing the things that are fun, right? I mean, most people that are able to co-parent, they go to the child's events, they back each other up. I told this story once on a podcast, I think, but I knew this woman who was divorced, and her husband lived just down the block. He bought a new house. She stayed in the family residence, and she was the primary caretaker of their 2 children. But they were so close to each other that when he got in trouble, for example, he got arrested for a DUI, she went over there and bailed him out. She got him out of there and stuff. But there was such a nice relationship that, the parties, they would attend each other's parties and things of that nature. And those kids were doing well. And so, I hope to see more of those. And I can't wait to talk to you more in depth about this at one of our future Exhibit A's.
Hopefully. That'll be fun.
Yeah. Well, thank you very much for joining us again. This was excellent.
Thanks for having me. Always a pleasure.
Okay. Thank you.